start. Though the High Court saw that the trial court extensively examined the evidence and considered all the submissions, it has nevertheless considered the evidence afresh and after a detailed examination, arrived at the same conclusion. We have given our anxious consideration and have scrutinized the evidence of all the eyewitnesses in detail. We are in full agreement with the decision of the trial court and the High Court. Their analysis and conclusions are based on correct appreciation of evidence and law. However, there is one aspect which stands out in the above referred analysis of the trial court and the High Court, and that pertains to the conclusion on the culpability of A3 for murder. We will now examine the evidence as against A3. A reading of the judgment and order passed by the trial as well as the High Court would indicate that neither the prosecution or defense, nor the court, have focused on the role of A3 as evidenced by the oral and documentary evidence. There is nothing to attribute A3 with the intent to murder the deceased. In fact, both the courts have mechanically drawn an inference against A3 under section 34 of the Act merely based on his presence near the scene of offence and his familial relations with the other accused. On considering the statements of the eyewitnesses, coupled with the post-mortem report, it is not possible to contend that A3 would have had the intention to commit the murder of the deceased, and as such, he cannot be convicted under section 302 IPC. Even though, A3 might not have had the common intention to commit the murder, nevertheless, his participation in the assault and the welding of the stone certainly makes him culpable for the offense that he has committed. While we acquit A3 of the offense under section 302 read with section 34 of the IPC, he is liable for the offense under 304 part 2 IPC. In the past, this court has considered factors such as lack of medical evidence to prove whether the act/injury was individually sufficient to cause death, a single blow on head with a hammer, and lack of cogent evidence of the eyewitnesses that the accused shared a common intention to commit murder as some factors to commute a sentence from section 302 to section 304 part 2 IPC. Pending application or applications, if any, are disposed of forthwith.